guys, it's me, Sylvia. I am here in the media room, and I am about to show you what happened in regards to the motion, this evening's motion. So I'm going to remove myself, and I will play it for you guys. Okay? All right. Hold on a second. Hold on a second. Just bear with me a second. Just hold on a second. I should put on my headphones so you guys won't have to hear all this other stuff that's going on in here. Um, where's everybody at? I don't see anybody. Hey, Kim. Hey, Black Beauty. Hello, Lady Coltrane. Where's all the folks at? Nobody sitting here today. All right, let's go. I'll put my thing on here and you guys can watch. All right, here we go. Hold on a second. Just wanted to show you guys what Doug had on today. All right, you guys, I know you got the ones that like to have the fashion show. But okay, I'm gonna get on to my main subject. Hold on a second. Do y'all see me? Okay, I just want to show you. Okay, thank you, Lady Coltrane. All right, let's go. Let me stop sharing this, and then I'm gonna go to the screen.
prohibiting dissemination of discovery pursuant to OCGA 17-16-4 Delta. And then the response to the state's motion for an order reinforcing the court's directive pursuant to that same code section, OCGA 17-6-4D. Let me recap what is alleged. And Ms. Bernard, you can certainly augment this, but I'm just going to put for the purposes of the record just what has been filed so I can rule upon it. On or about, councils, as you all recall, on September the 9th, I signed 2022, I signed an order specifically restricting the disclosure of discovery materials pursuant to this particular statute, OCGA 17-16-4D. And in section 5 of that order, it states as follows: all parties are prohibited from sharing discovery material with any news media sources, social media, or other public forums. It also, within that order, specifically details that the defense counsel is prohibited from sharing discovery with non-members of the defense team. Defense counsel may meet with potential witnesses and show discovery information to those potential witnesses as needed, but the defense counsel must prohibit those witnesses from recording, photographing, taking notes, or receiving a copy of any discovery materials. All parties, paragraph 5, are prohibited from sharing discovery material with any news media sources, social media, or other public forums. It has come to the court's attention through Ms. Bernard's motion and the state's motion that on or about February the 17th, some discovery material was disseminated on social media in clear violation of this order. That was apparently a witness interview of somebody that is going to be called potentially at trial. That particular video has garnered some over 30 million views on social media as of yet, and probably counting. And that would be in direct violation of this court's order. Now, you all in this courtroom are very seasoned advocates. And without I don't want to necessarily get into down in the eaches as to what or who might have disclosed this particular information, because I can't do that right now. And certainly it affects everyone's right to a fair trial under our U.S. as well as our Georgia constitutions, particularly the 5th and 6th Amendments in particular. But I want to just remind everybody about their obligations under those who are lawyers and who supervise paralegals and other support staff. Under Rule 1.6, which many of you probably not looked at it at 30 or more years, some of you that have been practicing that long, or varying lengths of time since you took the ethics course and passed the MPRE. That's the bedrock of our profession is confidentiality. And we're supposed to keep confidential information close and be close hold. So many of the things that we learn from representation, we can't share with anybody. This is just a prime example of a potential disclosure in violation of 1.6. Now, I don't know who did this, but if this pertains to you, then please kind of just amend your ways and kind of just think about how you keep information safe and who you're sharing it with, because you're playing a very dangerous game with your 6-digit bar number. Because one of the things I will do as a result of this disclosure is I will go ahead and order an investigation. And I'll tell you that the computer forensics folks are really good these days at finding the source of people's disclosure. So that's later, and I'm not going to take that up now because that's not something I'm equipped to do, but I am going to order an investigation in terms of that because my orders to you all are not aspirational. They're for the purpose so that everybody gets a fair trial. So if you think you might have leaked this particular information because you could tank your buddy or tank somebody else's ability to to have a fair trial, that would just be wrong on all levels. Like I said, I don't know, I'm not casting aspersions on anybody because I don't know who did it. But I'm just reminding you of your obligations as professional advocates to play by the rules. The rules are designed so that, especially the rules of ethics and the rules of discovery in this particular case, so that people can be protected, people can have a fair trial, people can have a lawful trial. And that's the only reason for it. And for this to have occurred and for me to have to deal with this at this point in time in the trial is just unacceptable. So I want you all to think about that. So Ms. Love, if you'll prepare a suitable order for my signature to order investigation, I will go ahead and do that. And as a result of this particular disclosure, this is the last time I'm going to have a conversation about this. If I have another conversation about the disclosure of information, then you're only going to get it from my chambers, either in the courtroom or in the jury room. I'm going to restrict it to that particular area for it to be looked at, because I can control that. So, as I said, this is not, and Ms. Bernard, thank you for bringing this to my attention. I'm sure that it would have probably come to my attention otherwise. At this point in time, Madam, however, I'm going to deny your motion for mistrial. However, I will permit you and your colleagues, as appropriate, as people come in, both sides, to ask them if they have heard about this video and if that affects their ability to be fair and impartial to your particular client or his or her interests, okay?
Yes, Your Honor, I'd just like to add, I appreciate everything that you said. The one thing that I would like to stress, when you were talking about what you were talking about just now, it felt like you were blaming the defense.
I'm blaming everybody. I'm not blaming, like I said, I can't determine who's doing this. You wrote that in your motion, madam. And I'm not casting aspersions. I'm not blaming you, and you did that in your reply to the state's motion. This is something that affects all of us. And until I find out, or if I ever find out who it is that did it, then I'll have that conversation with that person. But I'm reminding everybody, all sides, that this is something that is a joint responsibility to adhere to. 1.6 is the bedrock of what we believe and what we do as lawyers. We safeguard people's business and their secrets and their confidences, and we don't disclose them, even though it might be satiating and interesting and get other particular, be newsworthy. It's just not. And the reason that we signed this order, both sides asked me to sign this order, is because of the fact that we need to be able to safeguard information and individuals. That's why I did it. And that's why I'm kind of annoyed that the whole thing, that somebody just decided, hey, forget what the judge ordered. I'm going to just go ahead and release this. So, madam, to your point, okay?
All right, thank you, Judge. And depending on the outcome of the investigation, I may renew my motion.
Yes, ma'am. That certainly would be within your purview, if in fact I get it, whenever I get that done. Yes, Mr. Matthews.
Yes, Your Honor, on behalf of Mr. Huey, can we ask that the court reflect in the order that this is a joint request by both the government and the defense? Because I think we're all interested in determining this information, not just the government. No,
it's going to be my investigation. It's going to come from me.
Okay.
It's not going to come from any particular side. It's going to come from me, because it's my order that somebody violated.
And also, it's not going to, I'm sorry. And also, are you also saying that you're denying the state's motion to restrict our obtaining of discovery at this point?
Yeah, but if I have one more disclosure, you're going to get restricted. Your restriction is going to be not their office, my office.
Understood.
I would presume that will be after the investigation to determine how this got.
One thing at a time. I need to first sign the order, and then I need to kind of figure out where we go from there. That'll be something that I'll go ahead and let you know as it becomes appropriate. Okay? Yes, Mr. Jimenez.
Sweet chat again, so we have Mr. Dorsey. John, on your rule now, so you say that we ask, today is the time for us to let you know why their request shouldn't be granted. You're letting us know today that if there's another leak, wherever it comes from, we will be restricted.
I hadn't decided that yet, but that is one of the things that I potentially could do, because if I can't control who leaked it at that point in time, if there's another particular incident, I'm going to have to relook this particular issue.
Well, I find it necessary to bring up some issues as to the way discovery is being brought. And I also feel like I need to address this because it is under motion, specifically Section 2, where they seem to allude.
But you all have a duty as advocates
Absolutely.
to me, not me personally, you're a Glanville, but to the profession and the bench to adhere to the rules. So it doesn't make a difference who raised it. The state raised, you could have raised it. Ms. Bernard, did raise it. She was the first person to raise this under an issue of, she just moved for mistrial. But so it doesn't make a difference who makes the motion.
No, that's not what I'm trying to say, Your Honor. What I'm trying to say is that in their motion, they are specifically complaining that this leak happened after the defense.
But I can't determine that. I'm not going to determine that today.
So I just want to.
Can you just wait till I do the investigation? And then that's why I didn't get into all of that was put in the motion. We're not going to, it doesn't behoove your clients for us to discuss all that right now. It affects their ability to get a fair trial and a lawful trial. Just let me go ahead and do the investigation at this point, and then we can revisit this other who may be responsible at another time. It's just allegation and assertion at this point in time. So all you be doing is asserting some other position, and right now it's not the position's not important to the court. What's important to the court is a disclosure has occurred. It's been noted to me, and I'm not happy with it because somebody violated my order. That's the bottom line.
That's not what I'm trying to say, Your Honor. If I may just finish. What I'm trying to say is I think as a group, we have all identified a possible flaw with the way discovery is being released. And if I can express it to the court, maybe we can address that to prevent any future disclosures, whether they are intentional or not.
Well, I hope they're not intentional, because intentional will get you in a lot of hot water with me.
I can assure you it's not me. It will not get me in hot water because I am not disclosing anything. There is no staff. You're looking at the secretary, the executive, the senior, everything in my firm is done through me. And I can assure you there's been no leaks from the Chada Jimenez law. However, the state is providing discovery through an unsecured Dropbox link. Anybody with access to that link has access to the discovery. It's not even password protected, Your Honor. That is just the bare minimum for something that has a level of confidentiality to adhere by Rule 1.6. My discovery, as I requested and as they're complaining, is right here. This is my discovery. And I invite the state, look at it. You can't get into it without my fingerprint because I asked for it on a thumb drive, on a hard drive, so we don't have that issue. I am just saying, we are asking that if the state has any future discovery, give it to us in a secure form as a hard drive. That way I have it in my possession, not as a Dropbox link.
I don't have an issue with that if you provide the state with the drives.
Of course, I provided them that, but
that's a suggestion, certainly.
Yeah, because I definitely do not want to be restricted. I think we need access to the discovery, especially I don't want to be restricted if somebody else, whether it was from the defense or the state or some rogue officer or somebody that in the internet feels very passionate about this case and wants to start digging, the Dropbox is not secure. We need to do a better way. This is not new. This is just, even a password being assigned to that Dropbox link would have been the bare minimum. And this is the state providing the discovery on. I just wanted to bring that to the court's attention. I'm not here to blame anybody. None of us benefit from the leaks of anything.
And I appreciate that suggestion. That is a good one. And I think I will incorporate that for future discovery exchanges. Okay.
Thank you, Your Honor.
All right. Anybody else? Any other defense attorneys, I should say? Madam, Ms. Love.
Thank you, Your Honor. And I appreciate Your Honor addressing the matter of having an investigation into this plea. Your Honor, I wanted to point out in response to Mr. Chada's suggestion to the court regarding providing discovery on a medium to counsels for the defendants. The issue, I believe, originally was that they were unable to download videos and the like. And for the entirety of a year, I guess, that they had been receiving discovery via that Dropbox link that they could not download from, this type of thing had not happened to this extent. It was only after the court instructed and we followed the court's directive to place videos on that type of medium that 20 days later or so, this leak occurred. Your Honor, we will of course abide by whatever instruction and directive that the court gives to the state. But we also have in mind a more secure method of transmitting discovery to the defendants, which will require any person who downloads or looks at that to have a password and a marker will be placed on that item that they look at. Now, we can't prevent unlawful cell phones from capturing those things as they are viewed. But, Your Honor, we'd ask that the court allow us to endeavor to provide future discovery in this method that will at least place a watermark on the pieces of evidence that we provide to the defense.
Well, I think placing a watermark on what you have is a separate issue, and that might not be a bad idea for it to occur, because then if it's transmitted, you know where at least that was what you got from the particular discovery that was in fact it's made of record. And it's not a bootleg, but I do believe Mr. Child's suggestion of a drive being presented to you all, given to you so that it may be copied and they can, everyone has it can be protected by biometrics or password or whatever that nature. I just think we just need to kind of move to that at this point in time. So that's what I would ask that both of those two things be incorporated at this point in time from going forward. Okay.
And yes, Your Honor. And to be clear, the method that I was speaking of is evidence.com, which is the evidence holder for that the county uses that is secure, that we can send out discovery to the defense by way of.
Okay. Yes, Mr. Jimenez.
I just want to clarify, at no point, I requested the hard drives. At no
I'm sorry,
point.
no point. You what? I'm sorry.
Did I say I couldn't download it? I said it was too burdensome to download what it ended up being 2 terabytes. I have to download 1 file at a time. So I requested that they put it in a hard drive.
Yeah, I remember us having that conversation already.
Yeah, so
that issue. So.
The state just said that we claim we couldn't download it, and then after.
No. Look, let's not replow that road. I understand, and the court concurs with you in terms of, I think Mr. Matthews also brought that up earlier about not being able to view that. If it's on a drive, it's a lot easier for you to move it around and take it and show your clients. So, that makes sense. And I certainly think that would be appropriate. The issue becomes, again, keeping the confidentiality of the data that you're given or entrusted. It's not to be shared with the people outside in this order. We're not trying to prohibit, the court is in no way trying to prohibit you from utilizing it to prepare and otherwise show to those parties that you necessarily have to, but it just can't go on social media wholesale like this particular interview did. So again, please don't do that. I really don't want to have an uncomfortable conversation with any one of you, but I will go ahead and have this ordered, have this investigated. And I'll keep you all posted on that particular issue as we go forward. Anybody else wish to be heard on that issue before I go ahead and move on to any other ministerial acts, and then we talk about hardships for the afternoon.
Your Honor, and I do want to be clear so that we can make certain to abide by all of the court's instructions. With respect to the dissemination of discovery from this point forward, the state, of course, will be utilizing evidence.com as it relates to the downloading of materials to terabyte drives and the like. What is the court's instruction to the state and to the defense? Are they to give us something?
Yes, they're to provide you the appropriate terabyte drives for you, for that material that's subject to being disclosed for discovery, to be put on those drives in working order so it can be read or otherwise manipulated for their use.
Understood. Yes, Your Honor.
May I seek clarification?
What's your question, sir?
Are the existing Dropbox links going to remain open, or are we?
I recommend you terminate those. I recommend you move them to another space and place so that you can, or at least if it's not been password protected or otherwise enhanced in terms of security, that you do so.
Your Honor, and with respect to those links, each attorney has the ability to download from that link and then.
Why do we keep going back to this download? The downloads have been a problem. The reason the downloads are a problem because of the size of the material you have. So I think that you're gonna have to move away from that, Ms. Love. It's just too much. It's easier just to copy for their particular reason, since you've got videos and other things, to go ahead and just copy them onto a series of terabyte drives, then they're portable. So I would just direct you to do that. Mr. Steele, do you have an inquiry or a comment? You're next, Mr. Matthews, hold on. While you're what? I'm sorry?
While we're talking about this, and the state will tell me, but can you also put in your order, would you consider when we will have all discovered? Can you put a date on it, or as a state? I keep getting discovery and it changes.
Well, of course, you have a continuing obligation to disclose discovery. I would just say that, the state needs to disclose that within, have you given all the discovery already, madam?
We have.
Or 95% of it?
That we have, and as we collect it, we send it out. We endeavor to have collected and identified all that is identifiable by the April 28th date that the court alluded to earlier. If the court instructs us otherwise, then we will continue to disclose discovery throughout because we recognize our ongoing obligations.
But the reason I ask is because the state of Georgia is giving us discovery last month that they had in October 2021, excuse me. So it just seems like they have the discovery. And I just want, it takes a lot out of us to get ready and then it changes.
Sure. One of the things I might recommend you all do is just on a weekly basis that you or members of the defense, individually or collectively, talk with a representative from the state and make sure that you update your discovery. That might be the thing to do. I can order that to occur, that at least you have a conversation of, is there anything else that we need? And you pick a date during the week that you do that, or so that we can, so you can make sure that at least up to that point, you have everything you need. So I'll direct you to do that on a weekly basis, starting this week. You can pick whatever time you want. I'll leave that up to you all as professional advocates and go ahead and take care of that. Mr. Matthews.
Yes, sure, I agree. I just want to make sure that we have an opportunity to transfer our discovery to the proper USD and so forth and so on before the government shuts down anything boxes. We're going to take care of that.
They're not going to shut it down.
Okay, I want to make sure I hear the court.
I did say that they probably need to close that link or at least, but if you have existing material, I would just say that you just need to, Ms. Love, if you do have something open, you have 10 days, okay? From today's date to go ahead and download anything that is not otherwise onto an appropriate drive. And if you're not able to do that to the state, you provide those drives to the state so that they can go ahead and facilitate that download and you don't lose that information, okay? Yes, Mr. Jimenez.
And just, Sudi Chaki, man, on behalf of Mr. Dorsey. And to reiterate what Leonard Bernstein was saying, I think the issue that we're trying to get at is not ongoing discovery, newly discovered discovery, new postings, that's fair game. But I am requesting that there is a deadline for existing discovery because it should have been 10 days before trial. And I get it that there's a lot, and I get it that there's a lot of agencies. However, for example, this video, I think it came back in the link 9 from the Dropbox that this video was in, and they've had it for years. It is not newly discovered. If it's in the possession of them or law enforcement, it's deemed to be in the possession of the state, and we should have had it 10 days before January 9th. That's all we're asking. New discovery, yes. If I got discovery to turn over that comes up since then, I'll get it to them in a timely fashion. But old discovery that already exists and is in their possession, we're asking for it to be turned over by a date certain, and if not, to be excluded.
Here's what I'm going to do. I'm going to because we're going to be, I think, have some days that are down next week due to some unrelated business that the court has. I'm going to direct that you all meet on the 7th and 8th of March to have a discovery conference to see if you can resolve any and all discovery issues that may be outstanding. And then you can report back to the court. We'll pick up on the 9th and we can report back. You can tell me what you think is missing. But I'm going to direct all counsel to that is the state's counsel and the defense counsel on the 7th and the 8th of March to meet. You can meet in my courtroom in 8F and you all can have individual or collective conferences to make sure that you have everything you need. Okay?
And Your Honor, with respect to that date,
your clients will not be brought over for that date. It'll be attorneys. It'll be just for the purposes of discovery for that. Okay?
as there are things that we are requesting and have requested of certain entities, I would ask the courts to be allowed to inform defense counsel of those items and to commit to having them no later than April the 28th, because there are things that we are aware of that we are waiting.
Well, I think you need to tell them that. I mean, in the interest of full disclosure, I think that fosters just one, your responsibilities, and two, you're not playing ball, hide the ball with them. You're just telling them, hey, listen, we're expecting, to get a report from the GBI. It's been outstanding. They should have it to us by this date. You'll get it. So you all can track all of those, kind of outliers or even things that you've been promised by third parties. They can know that they, being the defense teams, can know, hey, well, we're tracking this and you're tracking that as well. But at least let's go ahead and get, I think having that conference for you all would be beneficial to make sure that everything's been disclosed thus far and that we have a plan going forward. Okay. All right. Anybody else? Anything else? All right, councils. Any other, we're going to switch subjects at this point in time. Any other ministerial inquiry with me before I go ahead and talk to Mr. Randolph and Ms. Von Kelsch for our next group of jurors? Okay, all right. Ms. Von Kelsch and Mr. Randolph, madam, sir, Ms. Von Kelsch, if you want to go ahead, and do you have any announcements that you wish to make? And can you tell us from this morning's examination what the preliminary pool looks like to be examined for hardship?
Yes, sir.
Come on up, madam. You can come up to the podium. I think everybody will be able to hear you at that point.
Okay. All right, so we had jurors 614 through 714 report this morning. And
Okay, guys, I just wanted to show you guys the hearing. So that was basically it for the hearing. Anybody have any questions for me? Let me take this thing off. Hold on, let me take this thing off. Okay, I had to take that off. Anybody have any questions for me? Anybody have any questions? Any question? It's about dragging your feet. Yeah, and you know, well, let me keep my mouth shut. I will talk to you guys about everything later. Because I got ears around here. It's about time. Stop dragging your feet. Yeah, I have lots of ears. So so anybody have any questions for me? Y'all, the pollen is kicking my butt. They didn't dismiss it. The judge did not dismiss it. Phyllis and later, okay. Yeah, my throat is itching so bad. My allergies because all that pollen outside. How can the defense bounce back from that leak? It should be a mistrial. Well, what they're going to do is ask the jurors, have they seen the tape? I'm behind on the details. What would he leak? Oh, Shakana, there was a interrogation video that came out that was leaked on the 17th, and it was all over the internet. And they said over 30 million people viewed it. So that in itself caused a problem for the case because supposedly he gave some information or something like that. So that's what happened on that. Do I have an idea who leaked it? Oh no, I don't know. I don't know. Oblivious, I don't know. Oblivion, I don't know. I really don't. I have not a clue. I have honestly, most likely a defendant, but unfairly affected the rest of them. You think it's one of the other ones? Because I know for a fact it definitely was not no Young Thug, because what the guy was talking is he was talking mostly against Young Thug. So I don't think it's any of them. I'm talking about Young Thug. I don't have a question, Sylvia. I just have a statement. I just want to say that I believe the judge was one-sided, but I believe he's coming around and he started to see the shenanigan. The judge seemed to be personally invested in this case because it should be dismissed. Let me tell you why it's not dismissed, P-Cash, because it's a lot of money has gone into this case. There's a lot, there's so much, and I think a lot of it is politically driven. So that's why they're not going to let this case go. But I believe this case is going to be either a hung jury or a mistrial eventually. That's what I believe. That's what I believe that's going to happen with this case because there's too much shenanigan going on. Oh, I actually saw that he was telling on Thug and get himself out of his charge. But let me tell you guys, he's in jail right now. Hey, Sylvia. Hey, Laura. I'm doing well. But Laura, you just coming in. I just played the video, the coverage from earlier's hearing in regards to the judge. So you probably get a chance to look at it, when I end this live. But how many plots and twists would nothing surprise me at this point? I don't know about a hung jury. You don't know? You don't think it's going to be a hung jury? You don't think it would be a hung jury? Janelle Sahan, okay, I read yours already. I think it would be a hung jury. Because nothing is concrete, you know. But the set, not at all. Oh no, you don't think so? I don't think a hung jury either. Really? Okay. No matter what, this trial can never be fair. No hung juries, too much evidence. Let them get a jury first. LOL. Me either, because there's a lot of evidence that points to Thug, even with the shenanigans. I don't know. I don't know. The other things is hearsay, because these other people actually did the murders, and they were done before. And half of them are serving time already. So they're saying that it was directed by him. So that's kind of hard to prove. So I don't know. Trials can go all kind of way. And remember, this is the state. This is not federal. There's a totally different beast in the state. This is not federal. It's totally different with the state, y'all. I don't think it'll be able to start. I don't know so much. Maybe a plea. But you heard the other ones. They said they'll take a plea, but only a plea that they want. They don't want the plea that they're giving them, you know, for them to talk or anything. They want to get free. I don't know what evidence they talking about. I don't know what evidence they talking about. I don't know. The thing they have to tow Thug is to everything, huh? The thing they have to tow Thug to everything. I don't understand that. Really, no evidence though, based on what's gone on so far. Then also the thing they have to do is tie Thug to everything. You will see when the case starts. Yeah, I will see when the case starts. I'll be right here for it. When they arrested Thug, he had a machine gun, which is illegal. But they can't use that evidence of the machine gun. Didn't you remember that? They can't use anything that they found in that house. They can't use the gun. They can't use the drug. Remember, the judge threw that out back in November. Nothing they found in that house could they use it against them, because the warrant, they didn't get a proper warrant, search warrant. That was a big win on that part. They didn't have a proper search warrant at the time of the search. That's for the old arrests in the old house, not the new house. Oh, well, we'll see, you guys, since everybody knows so much. We'll see. I'm not going to act like I know, because I don't know. We'll see. We shall see. Because if their case was so strong, why is it taking them so long to get this stuff over to them? Why isn't it federal? It's a RICO case. All RICO not federal. No, all RICOs are not federal. Because everything was done in the state of Georgia. The only part that would be federal, the gun part would be federal. Gun charges are usually federal. And the feds didn't take it. Because they said if the feds was going to take it, they would have took it a long time ago. They would have took it a long time ago. Because the way the feds move, y'all, the way the feds move, they would have took it. Nah, people on here low key hating, not even knowing anything. Miss Sylvia, shake my head. Yeah, at least I could say, Crushy, I don't know. All I'm doing is learning. But they don't know really. They don't know. When he first got arrested, Doug had a whole bunch of charges. Now he's down, and I'm not mistaken. Yeah, he's down to 8. Yeah, he had a whole bunch of charges. Yeah, they got rid of a whole bunch of charges that he had. Sure did. He had 50 something, and then now it's down to 8. You're absolutely right, Sharon. Miss Sylvia, did you see Thug fake? Yeah, I saw that comment on your last video. Trying to be. I didn't see the comment. Which comment? She left a comment on it. Which one? The one I just did? The video I just did, Tori? Hold on, let me see. Let's see. Oh. The last comment. Let's see. Hold on a second. I'm trying to see. Yes, the last live, she commented twice. Okay, hold on. Let me go in there. Hold on. Let me go in there. You be on it, Toria. Let me go check it. Hold on. Let's see. What did she say? Hold on. Let me go check to see what she said on my live. She trying to be slick, you said? Okay, what she said. Oh my God, you talked to his father. I talked to Jeff. Love, big difference. And he was sick. Jeff was not sick. What is wrong with this? Okay. Monroe. Famous Monroe 1. Where are you? You're probably in the bushes. Come on out. Come on out. Oh my God. Oh, Lord. I talked to Jeffrey. Love, big differences. And he's sick. He is not sick. He is not sick. Jeff is not sick. He is not. Will you stop it? What is wrong with these people? Oh, God. Oh my God. Oh my Lord. Y'all just don't know. The madness never. Oh God, y'all. The madness never stops. The madness never stops. Miss Sylvia, you really want to know about her aspect? Oh, I know, Crushy. I already know about her. I already know. I just don't, put it out on the internet. I don't, I don't deal with stuff like that at all. I try just to still deal with the facts of the cases and stuff. What information I get, all this extra additional drama and distraction. I must stay away from that. I must stay away from those kind of things. She does not talk directly to Jeffrey. I'm going to tell you that for a fact. She does not talk directly to Jeffrey. She does not talk directly to Jeffrey. I know that for a fact. She's not on his list to talk to. There are 10 people on his list, and he is not one of them. There are 10 people on that list, and she is not on the list. Okay? I'm going to tell you that for a fact. I know the people's names that are on that list, and she is definitely not one of them. She's definitely not. And I know she's probably in my bushes. And I know a lot of it is attention seeking. A lot of it has to do, money grab and things like that. But it's so strange. It seems like every time a celebrity gets involved with some sort of case, there are all kinds of weird people come out the woodwork. There's a lot of weird people come out the woodwork because the person can't speak for themselves. So they're making up a lot of stories to inflate their position of saying that they're this and they're that. I've learned a lot dealing with the R. Kelly case. There was family members coming out the woodwork, saying that they're this and saying that they're mentee's cousin and all this kind of craziness. And the reality of it is that because as long as the person stays in jail, these people can make up all these stories and folks starts believing it because they come out with that title, But as for her, I did ask questions of the family, and she definitely is not on his list. Definitely, she is not on this list. Crushy, yes, exactly. And that's one of the reasons why I did start this fight, because there's so much fake and news, so much negativity, so much sensationalized stuff that people go and they just start gravitating to that. And it's always the negative and crazy stuff they gravitate to. Just like, when I try to bring facts and information out, they don't want to listen to this. They don't want to listen to truth. You know that. But they want to listen to the sensationalized fake stuff. Yeah. And it's pretty sad. It's pretty sad. But I'm going to continue bringing you guys facts of what's going on in the case. That's what I'm going to keep bringing you facts, give you coverage, give you stuff that's going on, and anything that I find out, I will let you know. That's why I bring the documents and paperwork so you guys can see for yourself what's actually happening. It's not the big stuff right now, but at least you guys will know from the beginning what's happening, what it looks like, and things won't just come at you all of a sudden, Yeah, they do. They do crush you. They do. They do anything for crowd. So right now, the judge just ended court. He just ended court. He just ended court, and he was doing the hardship. So a hardship is over. Court has ended for the day. And what I'm going to do, I'm going to end my live, and I will see you guys later on with the coverage, okay? It's not much. It's more of videos and pictures and stuff like that, so you guys get to see the individuals, okay? Well, y'all saw him earlier, right? Didn't you get some good footage? All right. I'll give you better footage, the same one, but better ones. All right. Love you guys. I see you in a few. I'll be back on so you can ride home with me. Hopefully traffic is not too bad. All right. Love y'all. Bye.